All right, guys, welcome to DBL University 2021. Today's focus is going to be all about exhibit analysis and courtroom management. And let me just give you an understanding of kind of why this happened. So it was in the end of December, and we had just finished a hearing, and we were dealing with exhibits and courtroom management of those exhibits, and it really wasn't anybody on our side that was the problem, but it was someone from our opposing counsel side that was in complete disarray and disaster. And I thought to myself, at this point in that lawyer's life, if they don't understand simple exhibit analysis and courtroom management of those exhibits, their career will never advance beyond the stage that they're currently in. What a disaster. And I think sometimes we just need to have a refresher on the impact of exhibits. Number one, the management of those exhibits, and really what we do as lawyers when we put our exhibits in place, and what the court's analysis and judicial process is to evaluate those exhibits, and how can we do that in an efficient way and in a manner that best gives us the ability to maximize the effectiveness of that exhibit. And how many times, obviously you don't have to raise your hands on this type of format, but I suspect that all of you that have been in the courtroom on more than one occasion have either had a salty judge or had an opposing counsel or had a personal experience where you showed up in court and you thought, I've got this perfect exhibit that's going to nail this case to the wall for my client. And you get there, and for whatever reason, there's an analysis problem, there's an admission problem, or you just can't get what you need said to the court to make a record for that court to admit your documents. So today is going to give you an opportunity to kind of understand what I think is best practices in that respect, number one. And then you're going to leave with a couple of worksheets, 4 to be exact, that I think you can use too for every document that you intend, or other type of exhibit that you intend to introduce, number one. And then number two, 2 sets of documents that you can track your current exhibits during the course of your courtroom management of those documents. Why is that important? Number one, never leave one unsaid, never leave one unresolved. When it comes to exhibits, those are the evidence, those are the building blocks of your case. And then number two, don't allow the fog of war, so to speak, when you're in the middle of the battle in the courtroom. Sometimes the fog of war can creep in, and you think you've admitted it, you think the court's ruled on it, you think you've hit all the checks in the box of all your exhibits, but in fact, what happens is you find out after the fact that you have not. And so these little worksheets are going to give you an opportunity, and charts are going to give you an opportunity to kind of track those things, and they're going to be great, particularly if you're not necessarily the lawyer, but if you're the paralegal or you're the second or third chair down the line, helping that lawyer manage that case in courtroom or an administrative hearing. It's going to give you a great opportunity to make certain that you've met all of your evidentiary foundations and that you've checked all the boxes to get your evidence in front of the court. Okay, with that being said, let's kick it off. So Amy, if you would, the very first slide, please. What are exhibits? This is a crazy question, right? Because everybody thinks, well, I've been to law school, I should know what exhibits are. Really, they're anything other than testimony that can be perceived by the senses and presented at a trial or hearing. That's what they are. So they could be a number of different things, and I've divided those out into 4 types of exhibits. We're going to see that on the next slide, if you would. Exhibits really kind of fall into these 4 categories, and there can be maybe some, you could argue maybe some other categories. I think these are the ones that we see the most. Real evidence, which are tangible objects such as clothes, weapons, tools. If any of those, like if you have a products case, maybe a specific tool would be an exhibit that you'd use, because you'd want the jury to be able to touch it, to feel it, to see it in person, to see how it works mechanically, to see how it fits into the overall picture. And so tangible objects are great examples of real evidence that can be a type of exhibit. You have demonstrative evidence, evidence that represents or illustrates the real things, such as photos, videos, diagrams, maps, charts. We see these all the times in pictures. That's probably where we see them the most, where we see this type of demonstrative evidence. Records, government or business writings, hospital records, for example, police reports, when they can be made admissible, and payment records, that would be another example. And then writings, evidence other than records that are in writing, such as letters, receipts, contracts, promissory notes. Those are categories where all of these types of evidence will fall into the broader category of a type of exhibit. Why is that important? You'll see as we analyze the rest of these materials. Let's go to the next slide, if you would, Amy. Evidentiary foundations. So I'm going to move to another document in just a second, but let me tell you why I'm going to do that. The foundation of every exhibit is key to getting it admitted. The court, in its judicial process, is listening for authenticity. Is this document what it purports to be? And so look at these 2 bullet points. I'm going to walk through them real quick, and then I'm going to give you some real life examples. Before an exhibit can be offered into evidence in court, a foundation must be laid for its admission. When evidence rules require a fact or event to occur before an article can be considered evidence, that fact or event becomes part of the foundation necessary for the article's admission into evidence. The facts and events that must be shown represent a judgment as to what information demonstrates that the evidence is reliable and trustworthy. That gets back to the basic tenet of authentication. Is it authentic? Is it what it purports to be? For all exhibits, the first foundation that must be laid is that the article is authentic. If writings and records are offered to prove that the statements within them are true, a foundation must be laid that the article meets an hearsay exception. If a writing's terms are at issue, the proponent must introduce the document itself, the best evidence, rather than testimony of what the document says. So, all the time, and I say all the time meaning all the time, not part of the time. One of your best evidentiary objections to prevent evidence from being admitted is foundation. The witness is just assuming that we all know what this material is, and so therefore it ought to be admitted without any foundation to demonstrate how it even got to court. How did this document get created? Who created it? Is the witness that's actually talking about the document the person that created the document? If not, you have failed to lay an evidentiary foundation. You don't allow other people, you should not allow, and courts should not and typically will not allow people that are foreign to the creation of the document to come in and discuss its content. The exception could be expert witnesses, for example, but typically for you to be able to cross-examine that piece of evidence, that exhibit, you're going to have to cross-examine the person that created it. And so that's part of that foundation. Is this document what it purports to be? And the best way to know is to talk to the person who's sponsoring it, who is purportedly the person that created that document, or that took that photograph, or that removed that particular part, or that has used that tool, for example. And so with that in mind, Amy, if you would, I'd like to turn over to the foundation worksheet. So here's the first tool in today's set of tools that I want you to look at. It's going to be off of this chart, but Amy's going to share it with you as a worksheet. And then we're going to walk through that worksheet. So bear with us for just a second.
So which one is it, David?
It's the foundation worksheet. It's the one that's up right now.
This one right here? Okay.
Yes.
Let's see if I can get it any bigger. Maybe if I make it smaller. You can see the whole thing. Is that better? Oh, are you still seeing?
I can see it as long as everybody else can see it. It's just fine. And I created it, so I kind of have a pretty good idea of what the
trying to flip between the two programs, so bear with me.
And does that have a second?
It does not have a second page.
Okay.
Yeah.
So guys, this is what I call an exhibit foundation worksheet. And as you're working your case, as that case walks in from the very beginning, and Amy, is it possible you could make that just a little bit larger?
Sure.
Okay.
Better?
That's actually perfect.
Okay.
What I like to do is I like to identify each piece of evidence that walks in the door that I'm going to ultimately turn into an exhibit and put this as a cover sheet for my analysis of that particular document, the foundation worksheet. So what are the elements for the foundations necessary to get that particular kind of type of document in? For example, let's say this document is photographed and I'm going to get this photograph in. So what are the elements of foundation necessary? How how do I demonstrate to the court that this document is what it purports to be? So if you're a federal court practitioner, let's take the state out for a minute. If you're a federal court practitioner, you're going to know that you're going to have to get testimony that says that the person that took this photograph or the person that was there and observed the same scene that's depicted in the photograph. We just had a pop-up note. Is that about the audio?
We're good. Hold on a second. Uh-oh, getting tin can again. Okay, so yeah, so just try to be as focused as you can on the screen, I think, David, because your audio seems to be good when you're kind of looking directly at the screen. Thank you. I think that was Ashley. Thank you.
Okay. Anyhow, so the point is you're going to have to be able to demonstrate that the photograph is an authentic depiction of what was said. And most of us know that there is that specific catchphrase that every court wants to see. Is this fairly and accurately depict the photo at the time that the photograph was taken of the scene or of the object or of the circumstance? That would be an example of an element of foundation necessary. The person and the magic phrase. So you couldn't bring someone else in that's never been part of that scene, that's never seen that scene before, so to speak. It's going to have to be someone that is familiar with it at the time the photograph was taken. I also like to put on the bottom of that page any pretrial rulings pertaining to the exhibit. And again, this becomes your go-to page as that exhibit walks in for court that very first day in a hearing or in a trial. It's the cover page on your personal trial notebook. So you can say, I have hit every element necessary to get this in. I'm not inviting error. I'm not going to be in a situation where the court's going to overrule the admission of this exhibit. And I'm going to anticipate all of the objections that I might possibly get from my opposing counsel. And I'm going to make certain that the foundation is properly laid. That could be the date, should be the time, that could be if you were present, all of those necessary steps. Load it, make this a cover sheet as your admission to this exhibit starts during the course of your testimony and presentation. And then below, keep a list of all the pretrial rulings pertaining to that exhibit. So there may be motions in limine, for example, which are advisory in nature. You want to have a list of those things below, so when the court challenges you or the opposing counsel challenges you and says, wait a minute, these are absolutely not admissible until such time that the court rules in advance. Let's say there's a threshold ruling that's required. You're going to want to know that because in the heat of battle, all that can become conflated. And if you will keep this kind of document present for each of your exhibits, you'll be quick to not skip over those necessary components before you let the cat out of the bag and the court shuts you down. Why is that important? First of all, you want your exhibit in. Number two, and the optics of a court not giving you your evidence in front of a jury is actually horrible. It sets a very bad tone for the rest of your case and certainly the rest of your evidence. So keep that in mind. This evidence exhibit foundation worksheet is critical, I think, particularly when you have a lot of exhibits. Now, I've had trials. I can think of in 2011, I had a 22-day trial and 23-day trial in federal court, and we had 1,174 exhibits, 1,174 exhibits. Would it have been possible to remember every foundation? Would it have been possible to remember every pretrial ruling pertaining to all of those exhibits before trial? The answer is absolutely not. We knew we couldn't have used and we wouldn't have used all 1,174 exhibits. That was never going to happen. So there were going to be exhibits that we were definitely going to use. That's about 25. And then there were all the other exhibits that could have become important during the course of trial. So we literally had to create this type of foundation worksheet for each of those documents. That way, when we picked up that document and realized we needed to use it, we hadn't anticipated it, we wouldn't have any challenge of getting that evidence in when we needed it in the heat of battle. This is just one extra level of preparation, and it's key, particularly in big, heavy document cases, or if you haven't been in court for a while and it's not your thing, but you find yourself going this is a great way for you to go in with more confidence because you've got this, you're girded with this tool in your tool bag before you get started. So let's move away from that, Amy. Let's go back to the next slide
and
on the
just
list.
let me just interject, David, that everybody that had pre-signed up should have this in your email. I sent this out before the meeting, but don't worry if you signed up late. Lydia, our marketing associate, is going to send out the PowerPoint and the 4 documents again after the meeting. So just so that you guys know, you'll have a copy of this.
Perfect. Let's move to the next slide. It should be authentication.
Are we good? Does everybody see that? David, can you see it?
I've got it.
Okay, perfect.
So that next step, once we've started laying that foundation, the purpose of laying the foundation is to make certain that the court understands the document is what it purports to be. That's the authentication stage. A proper foundation means that the material must be proved to be an authentic document and to be what it purports to be. It's just very much that simple. This is all about basic fairness. You cannot interject things that do not support the underlying facts of your case. You can't create exhibits, for example. You can't manufacture evidence and turn them into exhibits. You have to use documents that are the genuine article that represent facts that occurred simultaneous with or concurrent with the events that you're trying to prove. Let's move to the next exhibit, if you would. Hearsay. So hearsay becomes a challenge, as I mentioned earlier. If a document does not create, if you don't have the creator of the document, if you don't have the photographer or someone standing and observing the scene at the time the photograph was taken, that's an example. Or let's say you're in a criminal case and often the person that's murdered is not available to come in and testify as to the events that he or she may have uttered that was recorded on a 911 call or something prior to their passing. So you have all kinds of rules of evidence that prevent exhibits from coming in based off of hearsay, meaning that the content of that document or that exhibit contains something that's been stated or created by someone other than the witness that is testifying to it in court. And they're asking the court or the jury to assume that that content is true for the purposes of proving the fact that's in question, right? That's a longer version of the traditional definition of hearsay. So real and demonstrative evidence do not run afoul of the hearsay rule. Writings and records often, when offered to prove that statements containing them are true, are hearsay. So if you have a gun, for example, that gun is not hearsay when you bring it as an exhibit, but if you have a report written by a third party about the gun, that is hearsay unless you have the person who wrote the report there to sponsor it in. It's different. So proponents of these documents, particularly those that end up falling to that hearsay, the writings and the records, proponents of these documents must lay that foundation. They must go through that element-driven foundation analysis that the documents are exceptions to the hearsay rule. Exceptions would include things such as, hey, Judge, the hearsay rule in this case does not apply because. Or you could also say this is non-hearsay because. And so we have a laundry list. I won't go through all the exceptions and the non-hearsay examples, but a laundry list of those in, I guess it's the 800 chapter of the Federal Rules of Evidence that you can refer to. For example, if an employer wants to introduce timesheets that show that a worker reported 15 minutes after the required time to begin work to prove that the worker was indeed late, the employer must show that the timesheets meet an exception to the hearsay rule. In this instance, the employer could say, we're going to produce these under the business records exception. So 803 sub 6, business record exception. That's an exception listed specifically by federal statute, and almost every state has a state analog to that federal rule that says if you can establish that you had a custodian of the records, this was regularly maintained as part of the company's record, this is a sample or example taken therefrom, then that's going to be sufficient to give the court enough confidence that it is what it purports to be, that it's authentic, that it's not a manufactured or created record for some other purposes, such as just for litigation, but it's a normal record maintained during the course of business. And as a result of that, the court's often and almost always going to allow that document to come in as a business record exception to the hearsay rule. That's just one example. There are many examples where exceptions to hearsay can be utilized. Amy, if you would move to the next slide. Here are some practice tips I want to kind of throw at you as it relates to the issues that we've talked about up to this point. And because I know at DBL we have a wide variety of different practitioners that do administrative hearings, whether it be government administrative type hearings versus trial. I've kind of thrown in both because I've done both. So in most administrative hearings, lack of foundation will not keep an exhibit out of evidence, but it will go to the weight or the credibility that the court will give that evidence. And that just really becomes the discretion of the hearing officer a lot of times. I've seen it go both ways. I've seen some hearing officers that are more lawyer focused and law focused that will say, I'm not allowing this evidence in, or if I allow it in, I'm not going to give it much weight since you don't have anybody to back the document up. And I've seen some hearing officers that are less acquainted with the details of the law that will allow it all in and pick and choose from it how much weight they give it. In court proceedings, however, unlike administrative hearings, in court proceedings, a lack of foundation not only will likely keep it out, it'll likely make certain that there's no mention of that evidence at all until such time that you can get it into evidence in a proper way. And so whether or not you're in an administrative hearing or whether you're in a court proceeding, in my opinion, the best practice would be treat it all as if you have to lay a foundation in advance. Why? Because a witness by which you can call that can lay a foundation for an exhibit is going to be able not only to give you that foundation, they're often going to be able to give you color commentary, understanding, details, context to that exhibit. They're likely to be the best person to answer questions on that exhibit, and you don't have to find yourself dancing around those issues, but rather you can take them straight on, and often that creates a different level of confidence. There's a testimony of being present and being prepared that just makes a difference when you're talking about documents, particularly key documents. That's best practices. Most foundations for exhibits introduced in a court are laid by live witness testimony. The pandemic has changed that just a little bit. So I have courts now that allow us to provide declarations or affidavits for documents that they previously would have never allowed for. Now we do kind of foundational testimony by declaration or by affidavit. The challenge with that is pretty clear. If the exhibit's being challenged, then the court's going to have to find another way to do it because there could be a competing declaration or competing affidavit. That's just kind of new pandemic rules that have applied as of the last 12 months. But the best practices is still, if you can, as a sponsoring lawyer, get your live witness testimony in, bring that person in, put them on the Zoom call or the Blue Jeans call or whatever kind of call it is, Ring Central call, and let the court see them, talk to them about it. And it also helps the court, should the court have challenges with the exhibit, to be able to ask your witness questions to further get a better sense of the authenticity of that document for the purposes of admission. Now, many times you will have more than one witness that can lay a proper foundation. So you may have a document that contains hearsay from multiple sources. And that happens particularly when you see documents that are created, a series of records that are created where you have different contributors to that record. Never forget and always remember, make a note that when you're doing your foundational analysis, when you're looking about how did you receive this document, who did you find this document, who was the best person to sponsor this document, you may have to have 2 or 3 people. Meaning, if you've had 2 or 3 contributors to the content and they were all independent of one another, all 3 contributors may have to come in and give some foundational testimony as to that content before that document can be admitted. So don't make the mistake. If part of it doesn't come in, usually all of it doesn't come in. And that can create a huge challenge for you if that exhibit's critical to your presentation. And sometimes, like I said, you're just going to need more than one to do it. Next analysis, or next slide, please. The mechanics of getting exhibits into evidence. Again, this will vary depending on if you're in front of an administrative hearing officer or if you're in front of a trial court. Administrative hearing officers, for example, in Oklahoma, we deal, in my past even more so, we dealt with administrative hearing officers in Department of Public Safety, for example, with driver's license issues or revocations or suspensions. You also see that you can have administrative hearing officers for such things as EEOC, EOC, and other types of less formal but still legal proceedings. And so let me give you some best practices, understandings about the mechanics of getting these exhibits into evidence, depending on if you're in front of one of those type of administrative entities versus a courtroom environment. So some administrative hearing officers require that all documents or exhibits be introduced at the beginning of a hearing. And if you've experienced this before, I want all documents. Often there's a get it to me 5 days in advance or some amount of time in advance. There's no discussion about authenticity. There's no discussion about any of these things. They want them all in. They want you to exchange them in advance. And then when they get there, they want to spend less time dealing with issues of authenticity and more time dealing with examination. The exhibits often in those circumstances will have to be numbered or lettered. You want to consult the specific rule for that administrative hearing officer to find out whether they want them to be alphanumeric or if they want them certainly just to be numbered, or how they want them to be numbered. If they want you and your opposing counsel to use a common scheme of numbers, in other words, don't use duplicates, but you all agree on how these documents will be labeled and meet in advance to make certain that they will not be duplicated. And any objections or arguments about the exhibits, whether it be relevancy or reliability, are made at the time of presentation. In complex civil litigation, most courts never allow for such a train wreck to occur like it happens in administrative courts. As we all know, we have docket control orders or scheduling orders pursuant to Federal Rule 16. Almost all of those docket control orders are going to have a date for exchange of exhibits. They're going to have meet and confer or attorney conference requirements where you meet with opposing counsel, you get your exhibits worked out. If you have a lot of exhibits, most courts are going to send you back and say, too many exhibits, go back to the drawing board, see how many of these we can stipulate to. If you have objections on those exhibits before pretrial conference, they're going to want you to meet and confer and discuss your objections and see if you can resolve your objections. Trust me, your foundations elements worksheet are going to be critical for those types of discussions with opposing counsel, even when you're evaluating their exhibits. And you're going to want to have all those pre-marked in advance. And again, there is a time component to that. It takes a lot of time, and the court's expected to do that. So the analysis has to start at the very beginning of your case, as soon as you receive those documents in. They're also going to want them all to be pre-marked and identified as part of that process. Still, other courts will allow you to introduce evidence whenever you choose. That's typically in non-complex cases. I find that often in municipal courts, in small non-courts of record, sometimes state courts, you have a more relaxed version of the rules. Find it, the witness can just show up, lawyers can show up, and they can just introduce evidence whenever they want without any real docket control measures in advance. So you'll want to know, and you'll want to check with your local court or with your municipal court or whatever court you're going to be in to present evidence. What is their rule? Do they have a local rule that applies? Do they have no rule that applies? Is there a statutory overlay that requires you to do certain things? Or has there been a docket control or scheduling order that has been entered that's going to have a specific line item that tells you exactly how and what method and manner your evidence is going to have to be marked in advance or at the time of and exchanged. And if you don't do those things, and they are mandated, you'll find yourself not in the good graces of the court. And I have seen courts deny the use of exhibits because counsel has not complied with their docket control orders. Very critical. Every court has the discretion to be different. And that's why we have not only federal statutes, for example, and local rules that don't supplant, but certainly supplement the federal statute. But we also have these really unique things in most federal courts that I practice in called chambers procedures. Meaning, yeah, we have all these other rules. We know you have to keep up with those. But in my court, I want you to do it even a little bit different than the rest of the courts. So you have to dig deep, either you or your paralegal or your administrative assistant, and look at all of those potential flags for how you must do it beyond just the statutory versions or the way you were taught in law school or how you're used to it in your other courts that you practice in. Even if, and I think this is important, you should always make copies of all the exhibits except impeachment documents. Impeachment documents are a little bit different. Why are they different? Well, because we anticipate we don't have to use them. We're not expecting to use these documents. We anticipated that the witness was going to tell the truth. Wink, wink. We thought that they would never get on the stand and lie and not tell the whole truth and nothing but the truth. So if you make impeachment documents available in advance, then you're kind of, number one, they're not truly impeachment documents. And then number two, you're tipping your hat to the court on the other side. Sometimes the best thing you could have happen in a case is for your opposing counsel to put up a witness that's not going to be truthful, or if you call an adverse witness and that witness is not truthful, and it's apparent that they're not going to be truthful and you can't refresh their recollection into truthfulness because they're just not willing to be truthful, then what you have is an impeachment document that can often seal the deal and the fate of credibility for that particular witness. If you would, Amy, let's move to the next slide. So always show, this is just practice tips. This is what federal court judges and state court judges typically expect to see, and what I think is best practice to prove to be a feather in your cap as a great practitioner too as you move through your careers. It's a good practice to let your opposing attorney know what exhibits you'll be introducing, particularly if you deal with that lawyer on a regular basis. Most courts require it. So if you have, let's say, here's an example. You're in a federal trial and you have, most judges are going to say to you, hey, by 6 p.m. tonight or by 7 p.m. tonight, I want an email exchange between the parties, include my bailiff on it, that says what witnesses you're going to call tomorrow and your anticipated exhibits that you'll be calling tomorrow. Why is that important? Because the court wants to streamline the issues. The court also wants to know that as soon as you walk in the court the next morning, hey, are there any matters that we need to take up about the proceedings yesterday or today? That's a great opportunity for you, if you've received the evidence that the guy is going to present that day or the lady's going to present that day, to say, Judge, we have a problem. There was a motion in limine filed. The court's given an advisory ruling. They intend to, or at least suggested they intend to do this. Again, you went back to your worksheet, your foundations worksheet. You looked at that exhibit and you said, this is the advisory ruling from the motion in limine. And you can go back to court and say, Judge, I understand what the ruling was. I understand what the court's expectation is. I fully intend to comply with that expectation. If the court would like me to make a proffer or basically a statement of how I intend to do so, I'm willing to do so now before the jury comes in. And the courts often will allow you to do it. And sometimes they'll say, you know what, we'll go ahead and take it up as it happens in front of the jury. If there's a problem, we'll move through it at that time. And I think as a practice tip, you want to have those documents exchanged in advance because that's what most courts expect, number one. Number two, you can often work out some of those challenges with the lawyers in advance. That's your last opportunity to have control over that exhibit, because if you can't work them out and they go in front of the court, then the court's going to control the admission of that exhibit. So I like to control my exhibits as much as possible, and I find that giving them to the other side in advance, girding myself with all the defenses, offenses, and defenses that I need for that exhibit is a better practice than going into the courtroom like a food fight where no rules apply and just slinging mud. Doesn't help. So get them done in advance, treat it more academically and less emotionally, and you shouldn't have any challenges. And oh, by the way, in most courts, these documents have already been exchanged in some other form through discovery or through your witness and exhibit list prior to pretrial conference. So it's not like you're letting a surprise, you're giving surprise documents to your opposing counsel. That's just not the case. It's just getting this thing narrowed for trial, making certain the court's more receptive to your rules, and getting rid of any nonsense arguments that might interrupt the flow of your trial presentation. Again, I mentioned it earlier, administrative officers also sometimes have I've seen 5-day rules and 3-day rules before hearings that require parties to exchange documents. That's important. It's different than different than a docket control order where it's the death penalty if you don't do it. Some administrative officers are a little bit more flexible, but if there is a rule there, you need to know it. You need to exchange them as a practice tip. You don't want to be the person not complying. Never reflects your best foot forward. And again, I mentioned again, there are going to be local rules and chamber procedures almost every single court. And if you find yourself in a court you know nothing about, for example, Derek, if I end up in Richmond, right, I want to know what that judge's thinking. I want to know what that judge wants me to do when it comes to exhibits, identification, or exchange, and how he wants them introduced or she wants them introduced. So I'm going to do my best to find someone that practices in front of that court as often as possible so I can adopt as my practice what that court wants. We find, and you shall find also, that when you do it the way the court wants you to do it, you're more likely to get favorable rulings. When you buck up against the system, you're less likely to get favorable rulings. And so there's absolutely no, you don't qualify or reduce your quality of practice by complying with what the court wants. What you do is you ingratiate yourself to the courts more often, and it presents itself to you or manifests itself to you often through more favorable rulings across the board. In any case, always be prepared to offer exhibits in the way that most benefits your client. Now, this is not something I recommend unless you have a great foundation of law to support your position. I've had courts that have said, this is the way I do it in my courtroom, and I've challenged it and said, I get it, Judge. I know why you want to do that. Here's the problem. Here's how it creates a challenge to my client. And so what I want to do is I want to get an evidentiary ruling or something in writing from that court before, if they're going to try to challenge the way that I do my examination. Often, you'll find this is the case in prior inconsistent statements. Some courts don't require that you ask a client or a witness, I should say, to refresh the recollection before a prior inconsistent statement is introduced. Other courts say, oh no, you must absolutely give them a chance to refresh the recollection before they'll consider it a prior inconsistent statement. And if you don't know that rule before you go in, and you are stuck on the notion that I'm not going to have to let them refresh their recollection and deny the statement, then you will get shut down all day long, and you'll never know why. And if you do find out why, it's too late because you've already shown your worst step forward in front of a jury, in front of a judge. So if you have a judge that's going to in some way compromise what makes that evidence best for your client, find out in advance, talk to them in advance, figure it out in advance, do whatever you need to do, or if you're even uncertain about a rule of evidence and how it's applied based on a chamber's procedures document that the court may have, you need to talk to them. Courts would prefer that you discuss it with them in advance, not during the time that you're on the record in front of the jury. So find a way to get that information in front of them, even if it's a status conference request for clarification of ruling. That's an example, and it can be done. Amy, if you would, move to the next slide. So there's a formal method, and I want you to focus on the formal method. This is, again, maybe what you would typically do, default to in most circumstances, unless there's a court or administrative office hearing officer that would force you into something different. The formal method is the method that you'll find most often used in courts. It's what most people have been trained to do. It's a 6-step process, and it can typically be a 5-step process if you have a docket control order in place that strictly forces you to exchange documents in advance and pre-mark them. So Amy, if you don't mind, I'd like you to move over to that next exhibit to get through these steps.
Do you want me, you mean in the
6 steps.
PowerPoint, or you're talking about a document?
Yeah, just slide 11.
Okay, perfect, sorry.
No, it's okay. So have the exhibit marked. Again, if your docket control or scheduling order under Rule 16 of the federal rules or your state equivalent, they're probably already going to have a requirement that you have these pre-marked before pretrial conference and exchanged. But there are courtrooms where this doesn't happen. There are courtrooms. I'll give you an example. And let me see, I see that Tim Kittle's on this call. Tim and I tried a capital murder case where they were going to put the guy to death potentially if we lost the case. It was an 18-day jury trial that ended on Halloween in 2013, I believe. So it was basically most of the month of October. And I had pre-marked exhibits in pre-marked notebooks, and the district attorney who was brought in had done 40-some capital murder cases as a prosecutor, was brought in from Oklahoma County, which is the largest county in Oklahoma, to prosecute this particular capital murder case that I was defending. He objected early into the case because I had pre-marked exhibits. And he in opposite to me, whenever he wanted to introduce an exhibit, he would fumble through hundreds of pages, pull one out, walk up to the court reporter and ask the court reporter, will you please mark this exhibit? I think we're on exhibit 22, I don't know, exhibit 19, we're somewhere in there. And it just looked like a train wreck, right? Like there was no continuity, there was no process. It was just whatever he pulled out of his stack at that moment, he was gonna have it marked as an exhibit. And then he had to try to figure out on the fly all of those necessary elements and whether any pretrial rulings had addressed those exhibits or not. And he objected because I had all of mine pre-marked, even those that weren't admitted yet, but I had them pre-marked in the notebook for the court to have a copy, for the witness to have a copy, and for both sides, opposing counsel as well as our table, have a copy. It wasn't required that we do that, but the judge stopped him halfway through his objection and rant and said, I'm sorry, counsel, this is the way they do it in complex civil litigation, and I see no reason why we shouldn't do it in this case. I had about 346 exhibits in that case, a big chunk of which were photographs, and it was so easy to get a witness to turn the page, turn to exhibit 14, turn to exhibit 324 in pre-marked exhibit binders. And it was easy for the court to follow. It was easy for the jury to follow. It was easy for the witnesses to follow, and it was consistent. And so it makes a difference. So even if you're not required to have them marked in advance, have them marked in advance if at all possible. So have the exhibit marked. Show the exhibit to opposing counsel. Let me give you an example. Counsel, I want you to refer to exhibit number 42, please. It's in your notebook, or you can simply say, I'm handing opposing counsel a copy of exhibit 42. Your Honor, may I approach the witness on the witness stand and hand them a copy of exhibit 42? Now, if you have them pre-marked, all you have to do is say, Ms. McKinney, will you please turn to exhibit 42 in binder number 1 or binder number 7 or whatever it is, which you'll have stacked up around the witness's chair up by the court reporter. You show the exhibit to the witness, or you allow the witness to look at the exhibit. Give them a minute. And I pause and I look at the jury, I look at the judge, I look at the jury, I look at the witness. I want to see how that witness is absorbing that document, and I want to see how the jury is looking at the witness absorbing the document. I want to see whether or not the judge in that case, if she's looking at the witness, if she's looking at the jury, or if she's just making notes or he's making notes on their own. But show the document to the exhibit and then start with the simple questions. Ma'am, have you seen this document before? Yes or no? And if the answer is, and obviously the answer is going to be yes, or you wouldn't be handing it to that witness, right? And you can typically from there start your foundation. You go back to those elements that we have on that worksheet and you walk through them. Have you seen this document before? What is this document? Well, this is an email that I sent to Miss McKinney on the 14th of December of 2019. Okay, so you drafted this email? Yes, I did. And you recognize this email? Yes, I do. Move to admit Exhibit 42. And the court's going to say, well, this person drafted it. This person recalls the content, or at least acknowledges that they drafted the document and can now look back at the document and will almost always admit that document because you've given it authenticity. You've demonstrated that the document is what it purports to be, an email from your witness to Ms. McKinney on December 14th of 2019. And then the content thereof becomes something that you can openly read from that point after you've moved for admission. Those are really the 6 steps. And again, that first step may or may not be necessary, and that second step may or may not be necessary if you have document binders that you've done in advance, the court has ordered, or you have taken the steps to do in advance. But these are traditionally the 6 steps that you're going to need to follow. Now, one other thing to keep in mind as a practice tip, Amy, if you don't mind moving to the next exhibit. One thing to keep in mind as a practice tip that I think is very, very important during this process. I have seen lawyers, particularly the more OCD lawyers like me, willingly admitting that I am. It took me a while to accept the fact that I might not have completely in order numbered exhibits. My trial binder for exhibits may be 1 through 36, and then 37, 38, and 39 may be omitted. And then I pick back up at 40 through 49, and then 50 through 57 may be omitted. I keep a binder in there that says omitted on purpose, okay, omitted by agreement, omitted by stipulation, or just omitted. So I know that I haven't missed anything, and it also gets me past my OCD challenges by having something in there that at least references why it's not there. But don't get in the habit of thinking at the last minute right before you get to trial that you have to renumber all of your exhibits. Don't do it. Another practice tip consistent with that idea is when you find yourself at depositions at that stage of the game in your discovery phase before trial, in any case, get with opposing counsel and say, hey, will you all agree to a common numbering scheme? So if I'm doing the first exhibit, I'm going to go, my exhibits today for this deposition are 1 through 27. So when you take a deposition of my client next Thursday, will you start with 28 and go from there until through all of your exhibits, or reuse 1 through 27 if you need to, so we don't have duplicates? If you start that in the very beginning of your discovery with opposing counsel, first of all, you're going to find out how many of your opposing lawyers actually have real trial experience, because no one wants to consolidate exhibits and change the numbering after the fact if they can avoid it. But you're going to find that your record is much more clear, particularly when you're using deposition transcripts at trial for witnesses that may not be present, so you have to read them in through deposition, or for prior and consistent statements, because your trial exhibit 27, if it's the same as your deposition exhibit 27, it makes more sense to the recipient, which is the court and the jury. And so it makes it much easier when you fillet this person at trial if they don't have to try to figure out how to compare what was deposition exhibit 12 with trial exhibit 27. If they both have common numbering, if you can get your opposing counsel to do it, you're better off. Most courts prefer it when given the option. So let's talk about opposing exhibits. I've given you some bullet points here. These are kind of best practices. I'm not going to read through these because there's something else I want to get to more with the time we have left. But this is just kind of important things to keep in mind in how you're going to oppose these documents. Authenticity is always key. Authenticity and foundation, always key. Hearsay, always key. Make certain you understand those. That's part of that foundational element analysis. If you have an opposing counsel that fails to put that analysis together in advance, then call them out on it. And if you have done a foundational element analysis worksheet for even your opposing counsel's exhibits, which I suggest that you do, then you will often have a greater command and often be more in tune with what the court's going to say in terms of their rulings on these pieces of evidence. Now, Amy, if you don't mind, I'd like you to direct off of PowerPoint over to the document analysis worksheet, if you would, please.
Yeah.
I tell the lawyers in our firm and any lawyer that will listen, when do you start your analysis for trial and for exhibits? And my answer is you start the very first day you meet that client. When that client says to you, hey, I've got 5 emails and I got this contract I want you to look at, you should start your analysis. How am I going to get this in a trial? Who's the witness that I'm going to need to call? How do I develop my case around this? And the answer is I wouldn't know if I don't analyze that document from the very first stage. And you can't wait until after your discovery is over to try to figure out how you're going to have your documents analyzed and used in trial. So here's a great tool that will give you the ability to do that. I call it a document analysis worksheet. The date the document was received. When did you get it? Who was the person, meaning what lawyer did you have reviewing that? Because I want to go back to that source. The date the document was reviewed, because I want to know early on in that process when it happened. When was the document created? Don't listen to someone because it has a date written on it. Look for the metadata if it's an electronically stored document, electronically created document. Find out what that metadata is. See if you can get it, it's a copy of it in its native format, how it was originally created, so you know exactly when that document was created, because that could be important in your timeline of your document, of an exhibit, and where you put it in. The analysis was prepared for. What was it prepared for? Was it prepared for the partner that's trying the case? Was it prepared for a hearing? All of that's important because the analysis may be different depending on if it was just for the narrative or if it was just for the early on, let's say the discovery plan, or if it was specific to a hearing where you're going to need more details. Source of the document. Who brought it to me? How did I get it? Was it provided to me by Amy McKinney and then she says, hey, I want you to see this document, David. It's very important. Well, Amy, this document purports to be a document that's an internal document belonging to our opposing side. How did you receive this document? Well, I can't tell you. Well, actually, you have to tell me, because if I don't know what the source of that document is, I may not be able to get that document in, because who's going to sponsor it in? Who's going to do it? And then the author of the document. Who created this document? Who took this photograph? Who drafted this contract? Those are critical, again, because you're going to have to get to that foundation worksheet so you can establish what are my foundational questions that I need. So here's your first sheet when you take this document in, and then your second sheet is that foundation element analysis. Summary of the content. So whoever you have reviewing the documents when they walk in, let's say it's a young associate, give me a bullet point summary, not War and Peace. Give me a bullet point summary that doesn't exceed 1 sentence per bullet point of what I can expect. What's this document here to tell me? What's this document here to say? Put it in bullet points. Relevance, evidentiary value. In other words, why is this document being presented? What is this document going to do to make my case better or to prove a certain fact? What makes it relevant to prove or disprove any fact in question in the case? Who knows? What's the potential benefit? Well, if I can get this document in, I can show that that person had knowledge in advance of their obligations and still failed to do so. Okay, obvious potential benefit. Doesn't have to be any more difficult than that, but you're putting this document in to show a purpose for it. What's the potential benefit? This document can support our breach of contract claim that the obligated party knew in advance that he had an obligation and failed to meet that obligation. Or this obligated party told us they would make a payment on the 13th day of December. They failed to make that payment. They promised us again, oh, sorry, the check's in the mail. Here's another email that shows that they continued to lie to us, that the document itself provides that potential benefit. And then what are the potential detriments? If I produce this document, does this document create in any way, shape, or form a challenge to my client or to the presentation that I want to make? And the answer is maybe it does, maybe it doesn't. But if you don't know that in advance, and if you haven't put that critical thought into it in advance, then you have no way of doing it on the fly typically, or you'll leave issues on the table that you'll never exploit or address if you don't do it in advance. Amy, if you wouldn't mind, please, if you'll go to the exhibit chart.
So is that another Word document? Yep, I see
it. It is, exhibit chart. So for courtroom management of these documents, we use a trial software that creates virtually this same kind of document, but you can take this document, you can use it to manage your documents. So if you have a second chair or a third chair, and if not in the first chair, you can still do it. The exhibit number in the left-hand column, a description of that exhibit, executed contract on December 12th of 2014. Was it offered? Yes or no? Check in the box. Was it admitted? Was it refused? Was it reserved? As the court said, I'm going to make, I'll reserve that ruling for later. Or did you ultimately withdraw the exhibit because you found that the evidence or the testimony didn't necessarily follow? I suggest that you have this type of chart for every case that you walk into court with, even a hearing that's not at the trial level. Why is that important? Because your job is to protect a record and to create a record as the trial lawyer. And so you'll be able to see where your gaps are by the time you get to the end of that proceeding. I've actually been in a trial before where the lawyer rested their case in chief I was defending and had failed to move for the admission of their exhibits. It's not my job to remind them. Once they close their case in chief, there's very few exceptions, there are some, but very few, that the court will allow them to reopen, particularly if there's a disadvantage. So what I do is I just move through my case in chief, at the end of which I move for a directed verdict. I ask the court to allow me to reserve that until the end of my case in chief. And then I can point to the fact that our opposing side has never introduced the abstract of title. They can't prove that they own the property. There is no self-authenticating document. The court should strike all the testimony in reference to it because it's not admitted in front of the court. You know what the courts will do? Two things. Their hair will catch on fire for a minute because they'll wonder why you hadn't said this earlier, and then you'll explain to them why you haven't. And then you'll ask them if they would like a copy of your exhibit chart to show that it was never offered. And then they're going to go back to their court reporter and they're going to say, ma'am, can you give me a dirty copy of the transcript so I can see whether or not these were ever offered? And the next day you're going to show up in court and they're going to say, they're going to grant your motion for a directed verdict, particularly if the other side has failed to offer it and there's no independent testimony that would lay a proper foundation for a necessary document that would be necessary to prove at issue, any matter. So an exhibit chart's a great way to chart where you are in a case at any one time and where your opposition is at any one moment. And because most cases require document exchange in advance, you can have this entire chart filled out in advance, and now you're just checking boxes as you go through trial. And you know what's been admitted and what's not. And how many times have you gone to court and listened to a lawyer that didn't recall if a document had been admitted or not, and they go down that path with redundant testimony, and they start asking the next witness this foundational questions. The court gets frustrated, the juries get frustrated, and the lawyer looks pretty moronic. So you can avoid doing that by having this type of document chart in advance. And Amy, if you don't mind, the exhibit list is the last Word document that I'd like you to pull up, please. And the last, but certainly not least tool, if the court does not require you to create an exhibit list and give descriptions, then this is a great tool that you can use you're going to want to know what the purpose of that exhibit is. So you can have the date of that exhibit, meaning the date of creation, the number of that exhibit, and a description. And often for me, what I find myself in is I'll have 15 exhibits that prove the same point. After about 3, the court, the jury, and everybody else in the room gets it. And I have to make the decision at that point, am I going to drone on for the next 12 hours talking about the next 12 exhibits so I can make my point and really grind it in? The answer is sometimes, yes, it's necessary just to show the depth of depravity of your opposing counsel's client. And then often the answer is no, because it becomes a major issue of redundancy and the court's not going to have the patience for it. So you have this description for that purpose. You can't be so robotic that when you get to court, just because you have X number of exhibits, you're guaranteed that I'm going to get them all in no matter what. Get the ones in that matter. Your description here on your personal exhibit list is going to give you a better understanding of what you're holding on to, how much gold you need to buy this witness, and how much you need to discredit this witness. And so you can select from this list which ones maybe you want to strike selectively once you've made your point and it's clear as an issue of fact that it's been resolved. So with that in mind, I hope you can use these tools. They've worked great for me for more than 20 years. We now have them again in an electronic form as part of our trial software. But if nothing else, you can walk away from today with the document analysis worksheet as well as the exhibit foundation worksheet and start evaluating the evidence as it walks in your door on day 1 and not waiting till the end to find out exactly the value of that case, because we don't want to spend any extra time or money or effort on documents that ultimately will never come in. And we certainly don't want to make that the building blocks of our case for trial if those documents can never be admitted in the future. The earliest analysis is often the best analysis, and then you can work from that analysis to further refine your understanding of that document and perfect it between there and trial.